Freedom was not garnered easily, therefore we should not allow the dissolution of those freedoms acquired by our ancestors and military servicemen to be easily rendered. The glass ceilings that exist today as barriers to the representation of American minorities cease to exist whenever the people of America are free and justice prevails with the protection of the United States Constitution. As a precedent set by our ancestors, the U.S. Constitution was established by European settlers for a free nation that included freedom of speech, freedom of religion, and freedom to gather. Free speech produces the social order that dominates our American culture. We believe that all of our constitutional freedoms come from the First Amendment and that it creates equality, freedom, and justice for all, and it protects our free American future with the past at hand. American politics remains integral to life in America, and it should be taught to our youth. The discussion of politics in the common narrative of our country is important. This is one facet of American privilege that can be amended to our basic education system. When there is more shared about the contributions of Americans in politics, we can see a form of social justice take place for the wrongs of the past that translate to the immediate remedy of modern-day situations, like mass incarceration, achievement gaps, wealth income inequalities, and lower life expectancies. Politics answers the questions of who we are as a diverse nation. To restate the commonly given idiom briefly, knowledge is power. We unify the nation when we learn about each other as citizens through politics and about our roles prevalent within them. With the knowledge of the past, we empower the disadvantaged by teaching them about their ancestry, which leads to a greater sense of pride in their citizenship, thereby opening up a door of opportunity to make America a greater nation with their inclusion. The history of our nation resembles a melting pot that we are all part of as a nation with independence, abolition, and civil rights accomplished across the ethnic lines of ancestry. Our legacy of freedom is integral to the United States. With politics, we bring about further assimilation, cohesion, and integration. The overarching theme to remember is that we did it together and we are destined to greatness together, and that America's legacy as a land of opportunity belongs to everyone. In fact, America was founded on the principle of freedom from tyranny, slavery, and injustice for all of its inhabitants. To learn how to further justice from hardship, we as a people must look at the efforts committed to it in the past to understand the issues presented to it, to address as effective policy and government today. These policies should be based on our history that reflect a version of equality which serves as an entire nation with a diverse people. This country should raise awareness of citizens in poverty-stricken areas with legal resources appropriate for the average education level in its communities for change. It is the role of government to reach the uninformed of the rights of These policies should be based on our history that reflect a version of equality which serves an entire nation with a diverse people. This country should raise awareness for citizens in poverty-stricken areas with legal resources appropriate for the average education level in its communities for change. It is the role of government to reach the uninformed of their rights as the duty of civic empowerment entails, according to the mandate of the Constitution as a democracy. This is not entitlement, it is the reenfranchisement of historically disadvantaged populations. The government should target populations of low socioeconomic status with its municipal governments to create mandates for due process, as it states in the 14th Amendment, to stop endemic homelessness, unemployment, and food scarcity as a government of a successful free nation with a fully functioning economy, as explicitly stated by Title 18 legal definition of forced labor law and Chapter 41 on extortion and threats. It is the prevention from a violation in the protection clause by the federal, state, or local government in the Constitution to hinder the exploitation of poor and other individuals by penalties from crimes as a criminal procedure. Our country is protected by the 10th Amendment in a democracy of a large, wealthy nation to exercise its right to legislation that furthers access to protection laws as a preventative method from threats of militarization that cause the dissolution of our union. A proactive response includes passing out pamphlets with this information sharing civil rights pertaining to lawful responses to incidents that may occur in the community. This may include in-services to kids or adults given by the police department at the request of campaigns for safer communities. Other ways to protect the community from common forms of violence that take place, such as gang violence, rape, and child molestation, is by raising awareness in the community about laws for preventative measures that includes an increase in reporting to law enforcement before matters end in serious crime. A safe avenue available to report any form of pain and suffering by witnesses, victims, and informants from a crime or crime that is suspected to occur is protected under the law through mental health care. Lastly, as a matter of opinion, emergency service responders from 9/11 to the fire department, police, constable, and others should be coached in certain scenarios to provide preventative measures. Professionals as emergency responders can describe which experiences qualify as mandatory preventative reporting to a Federal Bureau of Reports to be created according to the U.S. Constitution to safeguard citizens from criminal situations. Also, they may respond in action to principal actions taken by criminals. The law that requires a military response to be resolved. There may be a demand for community rights from the military. These measures are to be sustained as a presence under federal, state, or local law until a safer community that is free from organized crime is maintained. We should share the burden of organized crime in the community as a nation that has seen its militarization from mass shootings, bombs, and assassinations. When the stigma associated with mental health care is ruined, we can see it naturally combined with the Department of Defense as a line of defense for the entire nation to utilize as a potential to solve the crises of terrorism in America. Speeches have the ability to address disparities effectively for the government by focusing on the power to transform reality from the power of the podium for the United States of America. Similar to the delivery of Dr. Martin Luther King Jr. I Have a Dream speech of 1963, the practice of transformative thought given as a speech was proven by Henry Thoreau as civil disobedience and Mahatma Gandhi as nonviolence. King believed it was the duty of citizens to resist unjust laws that are the rule of law with nonviolence. Freeing Americans with his speeches is inspirational. There is no time for complacency. America has vowed to recognize the great upheaval that existed during his era today. It resembles the upheaval of politics in a post-racial society. Politics has the power to freely demand justice from the existence of oppression that should be addressed and transformed into freedom and justice. America marches on together as one army, and as we suffer for a greater cause, redemption comes. As it is stated in the Declaration of Independence, we hold these truths as self-evident that all men are created equal. With this faith, a statement of hope that can propel us forward from Dr. King should be recalled. Free at last, free at last. Thank God Almighty, we are free at last. In order of a policing protocol and the legend. In the legend of the following compendium against organized crime are the components to the law that must be understood and memorized to effectively serve populations for policing under the United States Codification, USC of the law, and the Code of Federal Regulations, CFR, as prosecutions by the country safely without overlap or corruption, including any falsehood or errors. The advantages of the compendium include a streamlined collection of laws that directly pertain to overcoming crime from organized crime in the 21st century. It includes a synopsis of the problem as analysis from the point of view of a survivor of organized crime and the author of the compendium against organized crime. Issues that are related to the last decade of major crime in the United States are included as disorderly conduct, terrorism, maritime law, mass shootings, and gang violence tied to any relationships with white-collar crime. A mandate for an additional amendment to the U.S. Constitution is also made to address the aforementioned needs of our country for the people that includes a subsequent USC and CFR for essential police and judicial enforcement. All of which may be amended to local law enforcement criminal procedure. This protocol has considered organized crime to be broken down by the observance of the law. It is created according to policing centered around becoming an addition to emergency responder coding using terms. The protocol relates to naval ships in connection to the deployment of troops within our nation from the military within everyday duties of emergency professionals. This will serve to unite the country on one front to better combat terrorism against the United States, which includes acts of terrorism on American soil or to an American building office off American soil. By unifying the law with a protocol, synopsis, and legend in simple terms that emergency professionals at any level can understand, our nation eliminates confusion, bureaucracy, and time wasted looking for solutions to crime without a record of threats for national oversight. A federal response will already be delineated as categorization for professionals to utilize. This is a cost-effective and greater efficiency for police stations, fire stations, emergency dispatch, 911, 911 and other emergency call services, ambulance companies, and military bases to use as communication research towards prevention, response, and ending organized crime anywhere it persists in the United States of America or abroad. In defense of malicious intent. The 28th Amendment, equal protection against malicious intent of persons. Law. A legal definition of circumstances for the rights of a victim, witness, or informant involves the protection from torture according to the freedom of life, liberty, and the right to property as evidenced by a violation that affects interstate commerce, maritime law, or territorial jurisdiction. The rights and privileges protected thereto include the jurisdiction of the United States Joint Chief of Staff for any subversive activity conducted as disorderly conduct, as a right to act by law to protect the state from an infringement of its founding. As the President of the United States with immunity from terrorism has forbearance of the law, as in any restriction to the setting of Supreme Court term limits may not be principled, and as the patent and copyright owners bear the right to protection from infringements, as witness, victim, or informant of two violations in the law, there is federal authority which reserves the right to act. The penalty is treason therein, punishable up to death, wherever it occurs as due process of the law. The definition of equal protection against persons of malicious intent clause. The Equal Protection Clause of rights from racial discrimination for crimes or violations to criminal procedures as legal search and seizure are entitled to the privilege of military protection for the freedom of life, liberty, and property, with a trial and jury before a federal judge, law enforcement, or both as protection to interstate commerce, maritime law, or territorial jurisdiction from being violated. It is cruel and unusual punishment to neglect, deny, or obstruct the justice thereto that the Constitution grants to states of the preemption of laws to protect its sovereignty. It gives that the state, estate, organization, or individual reserve the right to remain free from coercion, intimidation, or influence as a witness, victim, or informant of terrorism. States may exercise any constitutional representation of a person, entity, or organization as the law, free and inclusive to the nation to dictate its interstate commerce, transportation, or communication as independent of terrorism incurred under the law as an established right. Congress must respond to the racketeering, the embezzlement, or both of estates as a sovereign entity with the U.S. Constitution, and taxpayers are entitled to the privileges of protection under federal law against the malicious intent of persons as misbehavior that affects interstate commerce, maritime law, or territorial jurisdiction. The definition of mass shootings clause. A mass shooting, by definition, is an act of war against the United States of America. The nation shall declare war in response. The sovereignty of every state is entitled to a defense that remains in jeopardy by each act of senseless violence manifested therein as an objection to life, liberty, and property, until justice is deliberated by Congress and the Commander-in-Chief as martial law against an act of terrorism that is final. Response is economically defined by the purchase of vessels or other craft of war in emergency response to a maritime law, interstate commerce, or jurisdictional territory by the President, along with the Secretary of Transportation, the U.S. Navy, and the U.S. Navy. Congress should be notified by the President and its respective committees to keep America free from terrorism that transcends national boundaries and acts of terrorism committed on homeland territory as national security to the extent deemed necessary. USC 19, Section 4207A, mass shootings. A subcommittee to the Committee of Homeland Security shall be created by Congress to address every act of terrorism declared as an act of war under martial law, including the act of mass shootings and the destruction of maritime vessels at sail for the Department of Defense in order to remain a free democracy of the United States of America. It shall be rendered justice to protect the order established by government with this declaration of freedom from any acts of terrorism on and off American soil. Codification of federal regulations for equal protection against persons of malicious intent. Definition. The legal definition of the equal protection against persons of malicious intent is the equal protection of rights from racial discrimination from the crimes or violations in criminal procedures as illegal search and seizure that are entitled to the privilege of military protection for freedom of life, liberty, and property with a trial and jury before a judge, law enforcement, or both as protection to interstate commerce, maritime law, or territorial jurisdiction from being violated. Conditional basis. It is cruel and unusual punishment to neglect, deny, or obstruct the justice therein that the Constitution entitles to states as the preemption of lawsuits to protect its sovereignty. It gives that the state, organization, estate, or individual retains the right to remain free from coercion, intimidation, or influence as a witness, victim, or informant of terrorism. Jurisdiction. The state may exercise any constitutional representation of a person, entity, or organization that is designated by the law as free to dictate its interstate commerce, transportation, or communication, independent of terrorism under the law as a right. Policy. Congress must respond to racketeering, embezzlement, or both estates as sovereign under the U.S. Constitution, and taxpayers are entitled to the privileges of protection under federal law against the malicious intent of citizens as misbehavior that affects interstate commerce, maritime law, or territorial jurisdiction. The United States Codification, Title 18, Crimes and Criminal Procedures, Section on Equal Protection Against Persons of Malicious Intent, Chapter 65, Malicious Intent, Subchapter on the Equal Protection Against Persons of Malicious Intent. Purposes. For the purposes of racketeering and embezzlement for the given circumstances of the law, shall apply the jurisdiction provided by the law on equal protection against persons of malicious intent. Conditional basis. The conditional basis prohibits discrimination from equal protection against persons of malicious intent to the inclusion of race, ethnicity, national origin, gender, sexual orientation, or religious background in any act of terrorism. Circumstances in circumstances of coercion, intimidation, or influence as a conspiracy against the rights of an individual, entity, the states, or the nation in the form of torture from the racketeering of illegal contraband, organs, or persons. Jurisdiction. The jurisdictional basis of which it is created by terrorism, exploitation of persons, treason, and the obstruction of protective functions of the law and law enforcement, kidnapping, murder, attempted murder, or genital mutilation. Penalty. The penalty shall include that of mutiny, insubordination, rape, fraternization, counter-drug activity, or insurrection, not to the exclusion of the other. Results. As a consequence to the law, any evidence of illegal immigrant activity or contraband trafficking by any person or persons of conspirators of equal protection against malicious intent of persons under subsection entitled jurisdiction shall be subject to the entire policy of penalty to the law as an accessory after the fact and as a co-conspirator in section 2332b of this title. In defense of disorderly conduct. Withholding justice as a conspiracy to aid and abet attempted murder, or any other form of disorderly conduct defined by policing as a felony, a federal crime in principle according to the law. Any effort to obstruct a protective function of the state by an office under federal jurisdiction for an individual, minor, or the state may be subject to prosecution under the law up to death wherever it occurs. Predictive to the denial of justice in a conspiracy against rights include perjury and identity theft. And also there exist many forms of violence against an individual, a minor or elder, that are federal offenses of prosecutable under the law. Crimes that defraud the state include identity theft, perjury, impersonation of an officer, non-commissioned officer, petty officer, agent, or official, and proceed, embezzlement, and grand larceny. Types of violations of the law that are misconduct towards a constituent include misbehavior before the enemy, insubordination, withholding the written record as jurisdiction of the United States to protect against embezzlement and grand larceny. Statutes in the law that protect constituents of their rights from fraud by the government or terrorism include sovereignty, support for counter-drug activities, and activities that counter transnational organized crime, destruction of maritime vessel, abuse of office, and requisition of purchase of vessels in time of emergency. It is cruel and unusual punishment to allow a citizen suffering from organized crime to endure defamation, sexual harassment, discrimination, or the loss of health information without the defense of the federal government. The rights reserved for states from homeland terrorism in which it must protect its constituents at a risk of loss is provided by the Constitution, and the state has the right to protect itself from organized crime that may exist as damage to its integrity, such as illegal citizens or contraband. Lawsuits against the state for a failure to uphold the Constitution due to risks are constitutional for the prosecution of bodies, entities, or individuals. Situations that are punishable by government for the risk of blackmail or money laundering are covered under the 11th and 9th Amendments of the Constitution and Title 18, Part 3, in defense of terrorism. The rights given under United States Code subsequent to terrorism. According to the 14th Amendment, citizens have the right to equal protection under the law from any infringement upon their freedom to life, liberty, or property from racial discrimination. Under United States codification of law, any deviation from it is prosecutable offense identifiable as discrimination. The right of law enforcement to engage in the protection of citizens from harassment against criminal street gangs for the exploitation of crimes must follow criminal procedure as stated by Title 18 of the law and be punished up to the extent of death when it occurs for forced labor whenever it occurs. Disorderly conduct against the survivors of organized crimes prohibited by U.S.C. 36, Section 2.34, for control over the response of law enforcement to crimes that have been committed. An orderly response protects the victims, witnesses, and informants from being tampered with as a federal law over threats against justice as described by U.S.C. 10, Section 1512 that should be followed in situations of homeland terrorism. Further, it is illegal under any pretenses according to that statute to cause or induce any person to withhold testimony or withhold a record, document, or other object from an official proceeding, alter, destroy, mutilate, or conceal an object with intent to impair the integrity or availability of the object for use in the official proceeding, evade legal process summoning that person to appear as a witness, or to produce a record, document, or other object in an official proceeding to the allowance of any tampering. Any evidence of a crime, including its victims, under the protection from witnesses, victims, and informants of tampering law, is protected by the Fifth Amendment for life, liberty, and property, and the Fourth Amendment as search and seizure law. These amendments can be regulated by the United States Code 18, Section 2332b, from tortured victims as criminal activity against witness, victims, and informants. Any person that qualifies under any circumstances as an offender of the law under U.S.C. 18, Section 2332b of acts of terrorism and transcending national boundaries by interstate commerce becomes an accessory to acts of terrorism. Those individuals are liable to punishment by death when it occurs. Victims of terrorism are protected under federal law from terrorism by jurisdiction in interstate commerce. The burden of proof does not rest on the prosecution to prove that there was a target by crimes against witnesses, victims, and informants that violates interstate commerce of USC 18 Section 1512 by co-conspirators or accessories after the fact as a violation of the rights of survivors. Lastly, as it pertains to Title 18, Section 2332B, it is the law and the duty of the Attorney General of the United States to lead investigations of all federal crimes in the United States under Title 18, Crimes and Criminal Procedures, to the full extent of Constitution granted by the law. When death occurs, the punishment given for the crime is death by law. For example, instances of illegal organ harvesting when the definition of interstate commerce is jurisdictional basis for when the act of terrorism of USC 18, Section 2332B that transcend national boundaries terrorism is fulfilled. Any refusal to follow the law entitled as Title 18 Crimes and Criminal Procedure is an abuse of office subsequent to terrorism. A witness, victim, and informant of terrorism is entitled by the state to lawful rights from being denied. Protection from terrorism includes kidnapping to murder, as Title 18, Section 1512 designates for persons. To obstruct justice of a person from a judge or a federal penal officer or proceedings violates the law and is punishable with death whenever it occurs. To commit an act of obstruction of justice, corruption, classified under Title 18, Section 2381 as treason, mutiny, or subversive activities, it is also listed in Title 10, Section 894, Article 94 as mutiny and sedition. These crimes of mutiny are similar and punishable up to death whenever death occurs, along with the obstruction of rights to an office of a federal judge from rendering justice in a case of terrorism under federal law. These crimes are subsequent to denying the rights of witnesses, victims, and informants of organized crime protection in an obstruction of justice and criminal procedures to federal officers after the fact as co-conspirators committing fraternization. Any after-the-fact act as a conspirator to obstruct justice from fraternization is by definition defrauding the government, treason, mutiny, and subversive activity. And any act of Congress to further a federal crime with interstate commerce under Section 2332B1A of Title 18 is a crime of terrorism that transcends national boundaries with all jurisdiction under the law to its penalties, including death wherever it occurs. All co-conspirators that co-opt to defraud the law serve as an internal source of corruption, mutiny, and treason that are subject to full penalty of the law, including death wherever it occurs. If one person is an offender of Section 2332B as a co-conspirator or an accessory to terrorism after the fact, it is circumstantial evidence by definition and jurisdictional basis for punishment. It is a conspiracy to obstruct justice of any witnesses, victims, or informants, thereby violating the law and criminal procedure of crimes committed against the United States of America. It is the duty of the Attorney General to organize an investigation to reinstate justice. Any evidence of blackmail that threatens the president, former presidents, or U.S. interstate commerce is indication of tyranny that requires support with the gathering of defense material, its defense, or protection. International criminal activity to protect interstate commerce with the federal laws include the loss of national intelligence, drug trafficking, and organ trafficking. The United States remains sovereign to protect its interests to uphold the Constitution from any kind of racketeering or money laundering against its constituents. Any act of grand larceny committed against the state as embezzlement or its constituents may be rendered subject to penalty as violations of the rights of the Constitution. In defense of interstate commerce. In defense of interstate commerce, maritime law and territorial jurisdiction. The codification of the law as it relates to interstate commerce. The definition of interstate commerce means the identification and isolation of threats to the federal government. Under the conditions of extortion, the jurisdiction to defend the land protects against racketeering. In circumstances that give notice to policy that covers the definitions of interstate commerce as a part of terrorism is defined for the country. It is also terrorism to acquire a weapon in violation of interstate commerce and the response to illegal contraband activity or persons. In the response, The Secretary of Transportation may acquire any vessel for the cessation in the violation of interstate commerce and transfer the possession or control of any property or to any department or agency of the government of the United States upon such terms and conditions as may be approved by the President. USC 46, Section 1242. Circumstances with interstate commerce as precedent include sexual abuse of a minor, sexual exploitation of a minor, kidnapping, attempted murder, maiming of an individual, genital mutilation, laundering of monetary instruments, and racketeering. The types of jurisdiction that give power to those circumstances to serve include protective functions for racketeering, maiming, and genital mutilation. Interstate commerce is used to defend racketeering and kidnapping. In the definition of maritime law and territorial jurisdiction, to fight, attempted murder, and murder. The buildings and personal property definition of maritime jurisdiction and territorial jurisdiction protects victims of sexual abuse or exploitation of minors. Lastly, the definition of maritime jurisdiction for the U.S. defined is used to adjudicate justice against destruction of maritime facility or vessel. In defense of mass shootings. Federal codification of law in defense of mass shootings. Anyone that breaks the law is subject to the law, thereby principal to the law. A higher military order is necessary to combat racism, militancy, and radicalization as terrorism. A protocol of responses should be provided by the military, described by Title 10, Section 8063C, Needs of War. That includes de-escalating guns with more advanced technologies, such as a chip for digital guns, and legislation to restrict the manufacture of machine guns to protect the rights of the United States of America to serve its population. A subcommittee to the Committee of Homeland Security shall be created by Congress to address every act of terrorism declared as an act of war under martial law, including the act of mass shootings and the destruction of maritime vessels at sail for the Department of Defense. In order to remain a free democracy of the United States of America, it shall be rendered justice to protect the order established by the government with this declaration of freedom from any acts of terrorism on and off American soil. United States government has the power to collect taxes from citizens to function then as it is obligated under the law to those citizens as services to operate by the law. Specifically, members of Congress are compensated for their time in Congress to serve the people as the United States of America as representatives under the law. Therefore, there should be stipulations around the rules and regulations that come from Congress that serve the people during times of mass terrorism in the direction of military servicemen. This important mandate to Congress is described by Article 1, Section 8, Clause 14 of the Constitution, known as the Military Clause. The legal definition of the equal protection against persons of malicious intent is the equal protection of rights from racial discrimination, from the crimes or violations to criminal procedures of the illegal search and seizure that are entitled to the privilege of military protection for freedom of life, liberty, and property with a trial and jury before a federal judge, law enforcement, or both as protection to interstate commerce, maritime law, or territorial jurisdiction from being violated by terrorism. The conditional bases of mass shootings and the destruction of a vessel or maritime facility that it is principal to maritime law or territorial jurisdiction and affects to interstate commerce. It is the criminal act of war against the land of the United States and the people to act as a mass shooter according to U.S. 18, Section 2291, with an apparent determination and will to carry the threat into execution. When the cost is life as a threat, then the actor is subject to incur the death penalty with finality. It is criminal and unusual punishment to neglect, deny, or obstruct the justice therein that the Constitution entitles to the states as a preemption of laws to protect its sovereignty. It gives that the state, organization, estate, or individuals retains the right to remain free from coercion. A state or individual retains the right to remain free from coercion, intimidation, or influence as a witness, victim, or informant of terrorism. The conditional basis prohibits discrimination from equal protection against persons of malicious intent to the inclusion of race, ethnicity, national origin, gender, sexual orientation, or religious background in any act of terrorism. The purpose of the defense against mass shootings is our sovereignty to protect human life in our country with its integrity to the Constitution. Any acts of terrorism that take place should be subject to the entirety of the law that represents the nation. The act has therefore become principal to the law, along with its assailant that must be brought to justice for the law to be remain true to its originality. The jurisdiction required for the law under the law for mass shootings includes many operations to prevent and respond to dangerous acts of terrorism. They involve the homeland terrorism response that may incorporate other countries if necessary based on the background of the pursuant. It is important to seek any connection to organized crime to prevent similar events or the benefit of mass shootings towards future terrorism. This sort of crime is an act of war, therefore, with a tie to an insurrection against the United States that must be investigated for additional rebels. Along with any violation or interference of state and federal law, the presence of drug trafficking or drugs should be sought that threatens international law, national law, or the economy. In circumstances of coercion, intimidation, or influence as a conspiracy against the rights of an individual, entity, the states, or the nation in the form of torture, with the trafficking of illegal contraband, organs, or persons, law enforcement should execute all the procedural operations required to thwart any threat subsequently. The state may exercise any constitutional representation of a person, entity, or organization that is designated by the law as free to dictate its interstate commerce, transportation, or communication independent of terrorism under the law as a right. The jurisdictional bases of which is created by terrorism for the exploitation of persons, treason, the obstruction of protective functions of the law and law enforcement, kidnapping, murder, attempted murder, or general mutilation to be penalty for guilty persons. The threat to any act of terrorism after the fact from co-conspirators not apprehended at the scene of the crime mandate investigation to find principals to be brought to justice. Many times crimes are present on social media as warning signs displayed before the public that can be categorized as threats for future crime among the visualizers and jurisdiction for prosecution if no reports are made to forewarn authorities of threats presented. Barriers to reporting as social responsibility that is obligatory whenever the potential for terrorism to occur must become an obstacle for citizens to overcome. Any supporters of terrorism, including terrorists that aid and abet crimes committed, have to be eliminated before they become mutinous to the state as a right to the freedom of due process for the nation, which should be investigated with any ties to organized crime in accordance with the law to protect the country from de facto crimes. Crimes and criminal procedures should be extended to the response to terrorism and include the purchase of maritime vessels or the use of homeland maritime vessels to deploy troops from the U.S. Navy in order to find co-conspirators, accessories after the fact, and principals and bring them to justice. Congress must respond to racketeering and embezzlement are both related to terrorism under the U.S. Constitution. And taxpayers are entitled to the privileges of protection under federal law against the malicious intent of citizens as misbehavior that affects interstate commerce, maritime law, or territorial jurisdiction. The penalty shall include that of mutiny, insubordination, rape, fraternization, counter-drug activity, or insurrection, not to the exclusion of others as treason against the Constitution. As a consequence to the law, any evidence of illegal immigrant activity or contraband activity by any person or persons of conspirators of equal protection against malicious intent of persons under subsection entitled jurisdiction shall be subject to the entire policy of penalty to the law as an accessory after the fact and co-conspirator in section 2332b of this title, Crimes and Criminal Procedures. In defense of street gangs. In defense of street gangs, a summary of the federal codification of the law to eliminate the presence of terrorists, the discussion of street gangs from the law against acts of terrorism that transcends national boundaries is necessary. The main components of the acts of terrorism law to be identified include accessories after the fact, co-conspirators, and principals. A look at other laws relevant to street gangs with these components of acts of terrorism that transcend national boundaries law is sufficient to describe the legal components required to prosecute terrorists. In addition to USC 18, Section 1589, acts of terrorism that transcends national boundaries, examine the presence of street gangs from the activity of civil action from deprivation of rights and conspiracy to interfere with civil rights for officers of the law. These laws will describe petty or major crimes committed that define the actions taken and the penalties assigned to the extent of liability for the value of lost immunity, rights, or privileges in affirmation laws. As a prevention by law enforcement to street gang activity that are signs that future terrorist activity could occur, surround the persons acting as an accessory after the fact should be classified as potential terrorism and include those involved in tampering with a witness, retaliating against a witness, defamation, harassment, and sexual harassment. The potential victim of terrorism include places that are identifiable from accessories after the fact classified under USC 18 Section 2332B, acts that transcend national boundaries. As prevention by law enforcement to string activity that predict individuals that may be involved in future terrorist activity as co-conspirators should be classified as potential terrorists or terrorists and include those involved in conspiracy against rights, conspiracy to commit an offense or defraud the United States, interference with state and federal law. As prevention by law enforcement from principles, the following violations in the law should be taken note of with terrorism laws if influencing or injuring an officer or juror generally, obstruction of proceedings before department agencies and committees, or perjury generally. Crimes can be categorized by levels based on the severity of the crimes that are committed. For example, a level 1 threat is accessory after the fact, and co-conspirators that classification should be taken to predict terrorism. On level 2 threat for co-conspirators and principles of accessory and principles in which every precaution should be taken to prevent terrorism from occurring. Lastly, level 3 threat for crime that include accessory after the fact, co-conspirator, and principles when danger is real and imminent as the potential for future terrorism from street gangs. The key is to prevent crime before it happens. Examples of level 1 threats are crimes classified as terrorism under 18 USC 2332B that should be used to predict terrorism, that USC 18 Section 521 criminal street gangs are involved. Some indications of precaution that should be taken to prevent crime from terrorism are crimes that occur on level 2, threats such as laundering of monetary instruments, conspiracy to defraud the federal government, civil action for deprivation of rights, torture, mutiny, and sedition, and support for counter-drug activities. The most imminent and real signs of danger should be classified as those that include accessory after the fact, co-conspirators, and principles. This can be categorized as level 3 threats and should be used to stop terrorism predicted as likely to occur. These crimes include but are not limited to forced labor and major fraud against the United States. Version 1.0 Compendium for Marginalized People Groups. Title 52 Equal Protection of Marginalized Persons. Chapter 1 Underserved Persons Defined. Subchapter 1 Traditionally Disadvantaged Persons Defined. Section 1005 Disadvantaged Persons. Section 1010 Transatlantic Slave Trade and Segregation. And then it continues on. Again, Title 52, Equal Protection of Marginalized Persons. Underserved persons defined. Traditionally disadvantaged persons defined. Section 1005, Disadvantaged persons. Racial discrimination or malice for backgrounds that are constitutional freedoms are prohibited. Principles that aid and abet any prohibited activity including racketeering and grand larceny, or extortion with any form of discrimination described in this section that affects interstate commerce are subject to penalty for committing terrorism, violating the rights of marginalized groups of this title. The penalty for the act of discrimination as terrorism is a sentence that does not exceed 20 years, life, or death if death occurs, or a fine of a minimum of $3,000. Section 1010 Transatlantic Slave Trade and Segregation. Persons of heritage that is tied to the transatlantic slave trade or segregation of the United States shall receive a designation as traditionally disadvantaged persons as is defined in this section. Any discrimination of any persons that affects interstate commerce shall receive a penalty described by Section 1005, Disadvantaged Persons of this title. Subchapter 2, Non-Traditional Disadvantaged Persons defined. Section 2005, Non-Traditional Disadvantaged Persons. Persons without the heritage of a person tied to transatlantic slave trade and segregation of the United States shall receive a special class of national non-traditional disadvantaged persons as defined by this section. Any discrimination of such persons that affects interstate commerce shall receive a penalty described by Section 1005, Disadvantaged Persons of this title. Section 3005, Sexual Orientation, Transgender, or Sexual Dimorphism. Persons with a disposition of a person tied to sexual orientation, transgender, or sexual dimorphism, as defined by this section, victim to any discrimination that affects interstate commerce, shall receive a penalty described by Section 1005, Disadvantaged Persons of this title. Section 4005, Physical Disability. Any persons with physical disability defined by Title 42, Section 12101 is victim to any discrimination that affects interstate commerce shall receive a penalty described by Section 1005, Disadvantaged Persons defined by this title. Section 5005, Mental Illness. Persons with mental illness according to Title 42 that is a victim to any discrimination that affects interstate commerce shall constitute a penalty described by Section 1005, Disadvantaged Persons of this title. Chapter 2, Illegal Marginalization of Persons. Section 10,000, Anti-Racketeering Against Marginalized Persons. Now, the protection against racketeering of marginalized persons. Any tampering of witnesses, victims, or informants of racial discrimination or malice of any constitutional freedoms are prohibited. Retaliation by principals that engage in any prohibitive activity, including racketeering and grand larceny, or extortion as described in this section that affects interstate commerce, are an accessory after the fact to marginalization that are subject to penalty for committing terrorism, violating the rights of marginalized groups of this title. The penalty for these acts of terrorism is a sentence that does not exceed 20 years, life or both, if death occurs, or a fine of minimum of $5,000. Section 12,000, Prohibition against racketeering of minors, as is now called. Any tampering of witnesses, victims, or informants of crime against a minor, including discrimination or malice of constitutional freedoms, are prohibited. Retaliation by principals that engage in any prohibitive activity, including racketeering, grand larceny, or extortion, as described in this section, that affects interstate commerce, are an accessory after the fact to marginalization, they are subject to penalty for committing terrorism, violating the rights of marginalized groups of this title. The penalties for these acts of terrorism is a sentence that does not exceed 20 years, life or death if death occurs, or a fine of a minimum of $5,000. Chapter 3, Prohibition of Economic Espionage from Persons of Malicious Intent. Section 21,000, Protection from Economic Espionage. Any act of economic espionage against the rights of witnesses, victims, or informants of crime against a minor, including discrimination or malice of constitutional freedoms, are prohibited. Retaliation by principals that engage in any prohibited activity, including racketeering and grand larceny, or extortion, as described in this section, that affects interstate commerce, or an accessory after the fact to marginalization, subject to penalty for committing terrorism, violating the rights of marginalized groups of this title. The penalty for these acts of terrorism is a sentence that does not exceed 20 years, life or death if death occurs, or a fine of a minimum of $5,000. Prohibition of espionage from persons of malicious intent. Section 30,000, Protection of Espionage or Cyberspace. Any act of espionage against the rights of witnesses, victims, or informants of crime against a minor, including discrimination or malice of constitutional freedoms, are prohibited against activity in the United States or any prohibited cyberspace allotted to a user. Retaliation by principals that engage in any prohibited activity, including racketeering, grand larceny, or extortion, as described in this section, that affects interstate commerce, are an accessory after the fact to marginalization, subject to the penalty for committing terrorism, violating the rights of marginalized groups of this title. The penalty for these acts of terrorism is a sentence that does not exceed 20 years, life or death if death occurs, or a fine of a minimum of $5,000. UCMJ, subchapter, composition of courts, United States Code, military justice, composition of courts martial. 80, subchapter 5, composition of courts martial, section 8030.30, detail of expansion for jurisdiction to include civilian law. Definition of the detail to expand the jurisdiction to include civilian law is the illegal interruption of life, liberty, or property as prohibited activities when extortion occurs. Conditions include violations to interstate commerce, marine and maritime, and territorial jurisdiction. Do civilians protected by the rights of the 9th Amendment? Do the state protected by the rights of the 10th Amendment? Do the military protected by the rights of the 11th Amendment? And do the government protected by the rights of the 28th Amendment? Jurisdiction exists from grand larceny whenever disorderly conduct occurs, mass shooting occurs, a street gang occurs, and terrorism occurs. Policy is the right to court-martial all forms of extortion as any communication to the President of the United States by the Joint Chiefs of Staff and or defend the right to object any illegal jurisdiction by citizens and or foreign military with the conditions of jurisdiction according to definition in this section. USC 25, section 11.448, abuse of office. Definition: a person acting or purporting to act in an official capacity or taking advantage of such actual or purported capacity commits a felony if knowing that his or her conduct is illegal or he or she jurisdiction subjects under another to arrest, detention, search, seizure, mistreatment, disposition, assessment, lien, or other infringement of personal property rights, or denies or impedes another in the exercise or enjoyment of any right, privilege, power, or immunity. Penalty is subject to the fine of no less than $500 and or up to 5 years as a sentence. USC 52, section 121.05, first responders. A person acting or purporting to act in official capacity to take advantage of actual or purported capacity commits a felony if knowing that his or her conduct is illegal or he or she subjects another to arrest, detention, search, seizure, mistreatment, disposition, assessment, lien, or other infringement of personal property rights, or B, denies or impedes another in the exercise or enjoyment of any right, privilege, power, or immunity. Circumstances as a compromise of felony are withholding information, receiving compensation from a person arrested or liable to arrest, permitting escape, and as causation or sections of jurisdiction covered by the military USC MJ 5, section 830.31, which are permissible under this section. Jurisdiction: it is unlawful for any private detective or any member of the police force or of any other person to compromise a felony or any other unlawful act, or to participate in, assent to, aid, or assist any person suspected of crime to escape a full judicial examination by failing to give known facts or reasonable causes of suspicion, or withholding information relative to the charge or suspicion from the proper judicial authorities, or in any manner to receive any money, property, or favor, the proper judicial authorities, or in any manner to receive any money, property, favor, or other compensation form, or an account of any person arrested or subject to arrest for any crime or supposed crime, or to permit any such person to go at large without due effort to secure an investigation of such supposed crime. Penalty. And for any violation of the provisions of this section, or either of them, such member of the police force or private detective or other person guilty thereof shall be deemed as having compromised the felony, and shall be therefore prohibited from acting as an officer or a said police force or as a private detective, and shall be prosecuted to the extent of law for aiding criminals to escape the ends of justice. Policy. For jurisdiction, it remains legal to regulate interstate commerce that protects first responders from jeopardy and the marginalization of persons or malicious intent according to Title 18, Section 1000, and the sections of this title in the United States Military Justice as juris. We have USC 30, Section 31. UCMJ, composition of court-martials. Section 830.31, detail of expansion for foreign jurisdiction to include civilian law. Definition of the detail to expand the foreign jurisdictions of servicemen to include civilian law is the illegal interruption of life, liberty, or property as prohibitive activities when extortion occurs. Conditions include violations to interstate commerce, maritime and territorial jurisdiction, due civilians protected by. Similar to 830.30, to policy, the right to court-martial, policy subpoint 2, the foreign land presidency, consulates, embassies, heads of state, or parliamentary of martial law. And the rest is the same.